Our class today is on executorship. And we said trust and executorship accounting is all about we said is that branch of statute law, Cap 160, that demonstrates or gives guidance concerning the management of the estate of a deceased person. So what we are actually doing is going through the act. So today we are in Article 51 on the application of grant and how the protection of a deceased person's asset is supposed to be done. I'm sharing my screen. So there we are. So when we talk of the executorship or ab initio, from the word go, we said that a person will either die with a will or testate or die without a will, which we call intestacy. Now, irrespective of the death, the property of the deceased ought to be protected. Now, you don't choose where you will die, and you don't choose when you will die. So the reason why the Succession Act gives the provision is because death is an eventuality. It can happen when you've not documented your will, or it will happen when you are documented. Now, for those people who've documented their will is a bit easier because the will provides how the estate or how the wealth of the deceased person will be shared amongst the beneficiaries. They'll go ahead and appoint an executor. And today we are looking at the duties or the roles of the powers and the duties of the executor. Because when the person is dead, he takes over. And he takes over in a manner that is provided in the law or in the executorship statute law, that is Cap 160. And I advised people to go through the Cap 160. There's a lot that you can learn from it. A lot of knowledge that you can get from it. And maybe you're wondering, you're an accountant and what business do you have to do with the law? It's same as business law or company law. The reason why you cover the company law is to understand the limitations that have been put in place by the act. Yeah. So that when you are preparing, be it the books of financial, be it the financial statement as at the end of the period, you know, or you stand guided as per the company law. The same case applies to trust and executorship law. You might find yourself doing work in a law firm and you've been appointed as an accountant in a law firm. So when these things comes, you need to document all before you prepare the executor's accounts. You'll be preparing them later on after understanding the underlying issues. You need to have the background of the trust and executorship law for you to be able to prepare the executorship accounts. That's why. So take the pain, go through the notes, because it's a requirement for your profession. So we are talking of the property of a deceased person. It has to be protected, whether they had a will or no will. I take you back to your national ID card. If you look at the national identity card, the card is very particular. It is very particular on the district of birth. It's very particular on the place of issue, and is very particular on the other details are division and location. The reason why the registrar of persons take keen interest on where you are born and which is your location, which is your, we are trying to trace you to the last point, just in case you are missing. Well, our system, our security systems are not sophisticated, but if you go in progressive countries, a place like UK, it's very easy to trace a person, unless they commit suicide and they throw themselves in a borehole or somewhere that they cannot be, unless they miss, but it is very easy. America documents their people to the last point. So even the Americans who are living in Kabul, they can easily tell even when they die, because they do really document their people. But when you come to the third world countries, a place like Kenya, an ID is just a tool to let you access either government services or other services like opening a bank account, etc., or even voting. It's very important to the politician. But that identity card, the reason why we are calling it identity card, it's supposed to identify you from where you came from. When you are filling or when you are registering to get the ID, there is a place you even fill your clan, right? You have to document your clan. The reason why you give this information is in case of any eventuality, either you are missing or you are dead. Anything can happen, hata unaweza fiatuka, you can become of unsound mind. The government will be able to assist you and take you back to your people. When you are lost, you have unsound mind, you die, you get an accident, etc. That's the reason why we do seek identification. Now, we enter into today's class. We are talking of the protection of the property of a deceased person. So no person, when you die, no person may take possession or dispose, or rather sell, or otherwise intermeddle with any free property. Free property is what you purely own. So it hasn't been charged against any loan, so the bank cannot claim it. It is yours. Apparently in Kenya, do we have freehold titles or do we have what we call leasehold in Kenya? What is the nature of ownership of land in Kenya? Do we have freehold titles or do we have leasehold titles? Can go back and check. But you realize in Kenya, the only people who own land is the Kenyatta family, apparently. All the other properties, they are leasehold. So if the government wants to do anything on your land, they'll just approach you and say, Okatso, we desire to have a road on this land. So we are going to disturb you. We'll give you something small. You seek settlement elsewhere. And there's nothing much that you can do. The other day we had an issue when the government, the LAPSET project that is running all the way from Lamu to Ethiopia. Some parts of Isiolo and Meru were affected and people were suing the government. How do you sue the government and it is the owner of the land? So what you've been given in Kenya are privileges to use the land. So what you have is a leasehold title. I think Mzee Jomo Kenyatta was so wise and he documented his land to be freehold. But what do we do? So we are trying to say, if you own that property, yeah, you cannot, if you die, the property that you own cannot be disposed unless there is an express authority by the Succession Act. And this is where the executor comes in. The executor comes in to say that this is how the property of the deceased has been documented, and this is how it's supposed to be shared, or this is how it's supposed to be disposed of. So if a person contravenes the above, now if you intermeddle or you want to be clever and you want to dispose of or take advantage of the deceased person property, it's an offense and it is answerable. So if you are caught, it is answerable. So the executor can take all the necessary measures to ensure that they partake or take back what you are trying to take or contravene. Are we together? That's why the executor is very important. I know people asking, what about if you died intestate? You have a provision in the law, so we'll see. So whenever it becomes known to any police or any administrative office that any person has died, he shall forthwith report the fact of his death to the administrative office of the area, unless he knows that this has already been done. Now, in Kenya, we don't respect the dead. So you'll find someone has been kicked off by a motorbike, they are dead, they are outside your gate, but you don't care to report. You know it's illegal. If the government knows that you had information that there is a person who is dead outside your gate and you didn't report, they can follow it up. So it is the duty of anyone. This is the reason why we say that life is of priority. You cannot say that you are rushing to work, that's why you didn't report. Yeah? You are supposed to give the dead a priority, report. So to any police or any administrative office. From there, they are going to take action. Now, taking action is trying to identify the body, keeping the body in safe custody as they trace their family. Now, if the administrative officer is requested by any person who appears to have a legitimate interest in the estate, or if no application for representation in respect of the estate has been made within 1 month of the date of death of the deceased, the officer will proceed to the last known place of residence. How will they know the last place of residence? That's the reason why you have the ID, right? That's the reason why you have the identification card. So they'll go to the last known place of residence of the deceased and take all necessary steps for the protection of his free property found there. For ascertainment of his free property, or for ascertainment of all persons appearing to have any legitimate interest in succession to an administration of his estate, and for the guidance of prospective executors or administrators as to formalities and duties. You know, our law is 80% UK. Our constitution is borrowing widely from the United Kingdom's constitution. So some of this information that we are talking about, they just appear on paper. But what we mean is, legally, if the government realizes that there is a person who has died, they are supposed to follow it up to ensure that the interests of this person are taken care of and their property is protected. You've had cases where people will kill you to take advantage of your wealth. Africans are so selfish. The reason why we don't want to write our will is because of those myths, the bad omen that you will be caught in death, like you are wishing you die. You get, that's the reason why we don't document. But when you die, you can leave your family with a lot of problems and you had a lot of wealth. I was giving the example of the Kramer family. The father was a billionaire, but the children are left fighting because it was not documented. You get? So government is supposed to take charge and ensure that nothing is lost. But does it take charge? I don't know. That's for you to answer. Does the government take charge? We have a lot of unidentified bodies that are lying in city mortuary. So the High Court has jurisdiction to deal with any application and determine any dispute under the Succession Act. So this is what is supposed to happen. Assuming you died, yeah, and you had a will. So in the will, you had appointed the executor. Now the executor cannot just come in and start administering the estate of the deceased. No, they have to do what we call an application for grant. It is a legal process. So they should follow the legal process by applying for a grant of representation. We know they've been identified in the will as your representative, but now they have to legalize. So it means that before they do anything, they have to follow the right process and get what we call the probate of a will. Now, this is like a certificate to show that you've been granted the mandate to go ahead and administer this particular will, or to go ahead and start doing what is in the will. Are we there? So the application must include the following information: the full name of the deceased, the death and place of his death, that will be identified through the death certificate, whether or not the deceased left any will, the relationship, if any, of the applicant to the deceased, whether or not the deceased left any will. This is a repetition of number 3. The present, I think I should just delete it for the distort my notes. So I'll take you of that later on. Now, the present addresses of any executors appointed by any such will. In cases of total or partial intestacy, the names and addresses of all surviving sponsors, children, parents, brothers and sisters of the deceased, and of the children of any child of his or hers then deceased. Now, university graduates have a tall standing in the society. And this can happen to you, and you will be unable to advise if you don't know. Now, the first thing, or the most important thing when a person dies, is the death certificate. So we want to know what has been filed in the death certificate, because before the death certificate is printed, there should be an occurrence report. How did the deceased die? Where did he die? What killed him? etc. It is documented. And then summarily, it will be indicated in the death certificate. Now, the holder of the death certificate stands with a lot of authority, because by them holding that document, they can prevent anything as far as the administration of the wealth of the deceased from taking place. Now, assuming the father dies, and we have sons, and we have the mother, who has the priority of having the title? Not the title, the death certificate. Is it the mother? Of course, the sons will take advantage of going to file for the death of the father. Could be the mother is very weak because she is deceased. But what they can only do is to report. By the way, you won't be given that death certificate if the mother is alive. So there is somewhere that you feel. So when you say that you are the son, there is a following question. Is the mother alive? Okay, suppose it's the father who has died. Is the mother alive? Yes. That stops you from getting that title altogether. Some people will lie and take advantage of the situation. The reason is our system recognizes or really appreciates evidence. You cannot go to apply for a grant if you don't have the death certificate. So it is very important. This is one of the documents that is needed. The death certificate, to ascertain that the government have accepted that this person is dead. Do you know you can die and the government refuse to say that you are dead? Now, those are the powers of the government. The government can easily say you are not its citizen. You saw what happened to Miguna. So the government must accept that you are dead by issuing you the death certificate. And the death certificate is more important than the title, because it is the rider to getting access to all the titles of the deceased person. You get. So when you are advising, it's very important. Once a person dies, you know, in the rural homes, they don't take care of, they don't have a lot of regard to the documentation. So you find someone has like 30 acres of land, they don't even have the mother title. They don't even, it was just passed from the grandfather, from the late grandfather to the grandfather, grandfather to the father, father to the sons, etc. When you seek for documentation, it's not there. how will the wealth of that particular deceased person be administered when they die? In our community, the land belongs to the society, so it is believed that you cannot sell an inheritance property. But there comes a time, even the inheritance brings issue. How are we going to identify the right person who inherited? So a full inventory of all the assets and the liabilities of the deceased, of course, will be recorded in what you call the statement of affairs, and then such other matters as may be prescribed. The reason why we are saying this is over 90% of Kenyans don't have a written will, neither do they have an oral will. And we said an oral will must be witnessed by 2 witnesses. So the witnesses have to record, or they have to document what the deceased said. And we say that this can only last for 3 months. So an oral will, unless you die within 3 months, otherwise the will ought to have been documented for us to have and we say the only people who are permitted to take longer than that period is the military, or those people who will be in the war zone and they happen to die there, or the mission takes longer than 3 months. So you go on. Now, in the application, it is claimed that the deceased left a valid will. So this is what will happen if there was a valid will, or if the dead died a testator. If it was written, the original will must be annexed to the application for grant, or it is alleged to have been lost or destroyed otherwise than by revocation, or if for so any other reason the original cannot be produced, then either an authenticated copy thereof shall be annexed, or the names and addresses of all persons alleged to be able to prove its content shall be stated in its application. Now let me tell you what happens when people die. Even the executor can take advantage of the situation. They can connive with the people who are not appearing in the will. Now, the best way to store your will is have a safe custody. Safe custody is either you go to the bank, and there are those banks that provide custodial services. You keep your titles there. You keep your right now. You can even lose your degree certificate. And did you know that they are not duplicated, so you cannot be given another one? So whenever you want to apply for a job, you come to ZTech, they write a letter to the employer. So you can imagine if you're in somewhere like Busia, or even you travel to US, will be a pain in the wrong place. So I always advise people, whatever is important. I've seen, because I've had a privilege to work in the bank before. You will find people doing a wedding, and the ring are so costly. Let's say it's 24 karat gold. So if you walk with that ring in town, it can easily be stolen, by those people who knows what gold is. So people will just come and open a self-custody account in the bank, deposit the ring there. So they'll be coming for it when they are doing the, what do we call? When they are doing the remembrance, anniversary. That's when they'll come for the ring, and then they'll take it back the same day to the bank for safe custody. If people can keep a ring in the bank, why not a will? And the will has everything, and it will affect your generation that is coming after you. So what you do, you give a copy to your executor, but the original is supposed to be deposited with the custodial services. This will now protect you from the behavior. And when you do this, communicate to your beneficiaries. Tell your son, tell your wife, I have deposited my will with Cooperative Bank of Kenya. So shall it happen that I die, you can easily go and get the will or the copy of the will for administration. You saw what happened to Biwott when he died. Because of the exposure, there was no problem in the administration of his estate. It was so easy. He was a billionaire. Alikuwa amejipanga. He had written his will and deposited with the rightful parties. So if the executor wants to apply for the administration of the estate. Once the link expires, you can just log in. If it expires, if they want to do the application, they should annex or they should attach. That's what we mean by annex. They attach a copy of the original will. Now, when we talk of the authenticated, how do you authenticate? So this will is supposed to have been stamped by the advocate or a commissioner for oath. So you see, we can easily follow it up. You have annexed and you are saying that you don't have the original copy. We can easily follow with it. If we go to the attorney or the advocate who did the authentication or who did the certification, they are supposed to be having a copy in their file. So if they give us a copy and you brought your copy, it is easier to collate the due document if the original is missing. Secondly, the names and addresses of all persons alleged to be able to prove should be stated in the application, so we can easily follow it up. So granting an application is a process. Sometimes it can take longer because of the infightings with the relatives, etc., and also the interest involved. Lakini kama ulikufa bila kitu, no one will be interested. Just get buried and it goes. So if it was oral, the names and addresses of the alleged witnesses should be stated in the application, again for follow-up. No permission of any information from any application shall affect the power of the court to entertain the application. So you won't interfere with the ruling. Yeah? And any person who makes any willful or reckless statement now regarding all a false misrepresentation of facts, they are liable for an offense, which is punishable either by a fine of 10,000 or up to 1 year or both. So you can be fined and still be held up for 1 year. So a court may wherein, now that's where you misrepresent facts. Unaenda unadanganyana, I'm the executor. Then later on, the real executor comes in. You'll be followed by law. So a court may wherein a deceased person is proved, whether by production of a will or authenticated copy of the will, or by oral evidence of his content, to have left a will, grant in respect of all property to which the will applies either probate of the will, and I said that probate is a certificate of the court, now showing that we have a proof that the valid will existed, and therefore we are granting a representation to the executor or the person who will take care of the administration of the oath of the testator or the person who has died. Or where there is no providing executor, letters of administration with the will annexed, and if and so far as there may be intestacy letters of administration in respect of the intestate estate. So this will also apply where there is no will. So they have to prove first. So a court has the power to prove and grant the application. After they prove and ventilate the issue to see that there are no gaps and there is no misrepresentation of facts. F, a court may limit a grant of representation which it has jurisdiction to make as follows. 1, where the will has been lost or mislaid since the testator's death or has been destroyed by wrong or accident and not by any act of the testator, and a copy of the draft of the will has been preserved. Probate may be granted of the copy or draft limited until the original or the properly authenticated copy of it is produced. So a court can give temporary rights where the original copy cannot be traced. And that's why you are saying that it is very important to have the original copy in a safe custody. Shit happens, you can lose it. It can even be destroyed by fire. Yeah, in such a situation, only temporary. Now, by temporary it means if, for example, they are minors. No, we are human. Kama kulikuwa na watoto, they need to eat, they need to clothe, they need to go to school. So the temporary rights can only cater for humane acts, but you cannot go ahead and start selling or start dividing without the original. So when a will is in the possession of a person residing outside Kenya who has refused or neglected to deliver it, but a copy has been transmitted to the executor, and it is necessary for the interest of the estate that probate should be granted without waiting for the arrival of the original, probate may be granted of the copy so transmitted, limited until the will or the authenticated copy of it is produced. So those guys who are outside Kenya and they've refused to come back and they were having a will and the person is deceased, again, the court can give a temporary order subject to authenticating the original. 3, where no will of the deceased is forthcoming, but there is reason to believe that there is a will in existence, letters of administration may be granted, limited until the will or authenticated copy of it is produced. Same case. There are sources that the will is existing, but we haven't received it yet. Again, the court will go ahead and give temporary letters of administration for human issues as we await for the copy to be produced. So when any executor is absent from Kenya and there is no executor in Kenya willing to work, letters of administration with the will annexed may be granted to the attorney of the absent executor for the use and benefit of his principal, limited until he shall obtain probate or letters of administration granted to himself. To see what is happening, the law is assuming that everyone has an attorney or a representative, isn't it? I don't know whether it is the case in Kenya, maybe in UK. But if that is the case, we are saying if the person is not in Kenya, we can approach the attorney of that person to represent the duties that he was supposed to give or that he was supposed to have played as the executor. But this can only be until himself he applies to be given the grant to administer this. We cannot force him. We can just approach the attorney. You are coming here because you are the representative of so-and-so who is in Qatar. Are you willing to go ahead and perform his duties, or can you talk to him to execute on his behalf? If he says yes, we'll ask him now to go ahead and apply the legal way. Then 5th, when a minor is the sole executor, there are those people who will appoint their children to be executors, those people who have trust issues, or sole residuary legatee. He's the only person who's been identified in the will. Letters of administration with the will annex may be granted to the legal guardian. Remember when we were talking of loco parentis, that person who has taken the duty of your parent will be given now the letters of administration, or to such other person as the court think fit until the minor has attained the full age, at which time and not before probate of the will is granted to him